I'm signing on to his new case.
Oh, we picked up a new case.
We did, Judge.
Mr. Palacio, you're now charged with the new case. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes. On February 5th, 2025, the officer was dispatched to a stranded vehicle at the 700 block of North Sam Houston Parkway, and the officer observed a car parked on the shoulder and a driver asleep at the wheel with the engine running and the car in park. The officer knocked on the window to wake up the driver, who woke up and refused to comply with the officer's command and drove the car 6 feet forward. The officer then requested the defendant exit the vehicle. The defendant put the vehicle in park, then drive multiple times before finally exiting the vehicle. The defendant was detained upon exiting the vehicle, and the officer relocated to a gas station where the defendant was observed to be dazed and confused and did not realize he had been asleep at the wheel. The defendant was also unable to communicate where he had been or where he was going. The defendant was asked to perform standard field sobriety test, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand, 1 out of 4. The defendant was read the DIC and declined to provide a sample. A blood search warrant was signed and executed.
I'm going to find that there's probable cause to go forward with the case. Can you look to see if he has any prior DWIs, and does he have a valid Texas driver license?
He does have a valid driver's license, Judge, and we did file for the ALR hearing.
And then I see he has a dismissed DWI out of Fort Bend, but no other DWIs.
There's no probable cause in that case.
I'm now ordering you, well, the first thing I'm going to do is I ordered you on your first case not to consume alcohol or illegal drugs. You've now picked up a DWI.
The hearing began with a defendant who believed her constitutional rights had been violated. She claimed her former attorney pressured her to accept a plea deal before she had fully reviewed the evidence, but the judge quickly shifted the discussion, emphasizing that the court was focused on the next steps of the case, rather than revisiting past disagreements between attorney and client.
He did it, picked up a new case. You're staying with me. And I'm going to tell you now, if I find that you consume alcohol again, I will put you in a rehab facility myself, in the jail. And if you respond well to treatment, it's a minimum of 9 months. Do you understand?
Yes, sir.
I'm now placing a restriction that you're not to drive any vehicle that doesn't have a guardian interlock on it. You're not to consume alcohol, illegal drugs, and Casey, I'm now going to probably give him a curfew. In the BMV, was he out in the middle of the night? Alex?
Yes, Your Honor.
I think it was after a bar closed. He was just sleeping in the owner's vehicle.
There's one consistent problem, and there's one thing that centers around every single problem that you have. What is that one problem? Right. You and alcohol do not mix. And I don't know what we need to do to get you to realize that, but I don't know. I hope that this is it. If it's not, it's going to be rather lengthy. Maybe that's it. Is it prison? I don't know. But all of the issues center around one thing. And I hope that you now realize this and do what you need to do. Because if you can't take care of it yourself, I will do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Okay, it goes with you. And then when he comes out, or when he does bond out, he's going to have to come back for bond conditions, and then we'll carry it.
His bond conditions today on the non-revoked case, so they'll be active.
Okay.
And then do they want a device other than the ignition interlock?
No, just, what time was,
The time that it took place, is the only time the officer gave is when they got the blood samples, and that was at 7 a.m. So sometime prior to 7 a.m. But he doesn't say how long before the blood was actually drawn.
what do you think about a curfew?
Judge, if I may, he is active military, so he is Still reporting to that. They're also looking to get him help. He has enrolled himself in IOP, so he does have a job
I
in the
won't
military.
put the curfew, but if he
Okay.
picks up a new case,
I understand. We had a big conversation and he's the one that took it upon himself to realize that this was a problem. And he told me that he was going to use his VA benefits to look into the IOP at this point. So he
Alright.
did send me that email that he is confirmed to begin enrollment in IOP.
okay, so, on the DWI, just pick whatever date you have.
Okay.
When he does bond out, he'll get a 7-day setting.
Mhm.
Whenever day that you get, just let Ramona know or Victoria, and then we'll give you that day. Just feel free to email them and then we
Okay.
can carry them.
Just put them both on the same
Yeah.
day.
Okay, all right.
I think we addressed Gary's bond.
I was gonna set it at 5,001.
Okay.
That's what I normally do.
Okay. Thank
Okay.
you guys. I
Yes,
just wanted to be sure to have one.
Okay, thanks. Sorry, Ms. Finn.
I just filed a revoke and raise. He picked up a murder charge. Yeah.
Yes, sir.
Wow.
This last week. This is the young guy that, he is,
How old is this kid? What happened?
17.
17, he picked up a murder case. What happened?
From my understanding, it was a weed deal gone wrong.
Oh, I read about this, right? Really? I'm so disappointed, Mr. Jones. I can't tell you how disappointed I am, you know? We've got but one life to live. Just one. You don't get you don't get multiple chances, man. You're not a cat. I'm bringing you out here because we're talking about you, and it's only fair that you hear what's going on. Because you've now picked up the murder case upstairs, the state has asked me to, your bonds are now set on both of your.
By this point, we've already seen bond revocations, DWI warnings, and even a murder charge pop up. But here's the bigger question: are these courtroom restrictions enough to actually stop repeat offenders, or are they just temporary fixes?
Cases on your assault and your criminal mischief, they're both set at 5,002. They did not give you a PR bond on those cases, and the state has asked me to revoke and raise those cases because you are a danger to our public. You've not made bond on those cases, so I'm going to deny their request to revoke and raise your bond. But I'm going to tell you now that I don't know if you're going to get out because your bond is set at $250,000 upstairs. But if you do, I don't want you to go anywhere. I want you absolute home confinement, 24 hours a day, 7 days a week. Do you understand? And you will have a GPS monitor, no drugs, no alcohol, no weapons, anything else?
No, Judge. Not from the scene.
And I guess just keep me in the loop what happens upstairs, you know, if they do anything with the bonds, just keep me in the loop so we can kind of stay close. The other thing is that thing's going to take a while to play out. And I mean, I'm not going to hold it for 2 years for it to play out upstairs. So let's try to find some kind of resolution so we can, you know, they can worry about it upstairs and then we can just, okay?
Yes, sir.
I'll obviously give you a sufficient time. Is discovery complete? Because these cases are from November. They're old.
We're still waiting on body cam, dash.
I mean, that's not good. I mean, wait a second.
November. It's
I guess they may have been 2Bs though. Let me see if that's right. Because if there were 2Bs, then
Actually, Judge, it looks like we have all of the body cam. It just wasn't complete. We have the 911 calls.
oh, so you've got, discovery's complete.
It looks
Okay.
like it, yes, Judge.
Have you given offers on both of the cases?
I have not, Judge, but I'll take a look on his,
There was an offer, but it's been rejected.
There was-
Counted out that option, that offer.
we had offered a 13-month deferred. I revoked it, obviously, with the new law violation.
Sure.
So I'm probably just gonna check his credit and put a jail time offer.
Okay, so I'll give you some time, take a look, speak with Mr. Jones, what he wants to do. The cases are kind of old, so when we come back the next time, you must accept the offer from the state. Otherwise, I'm going to set your cases for trial here. You understand? Okay, man.
But Judge, in all honesty, I can let him know right now, considering that he has a murder case, I would be, reluctant to plead him guilty to, an assault case. Because that could be used in punishment. He's in enough trouble. We may as well set the trial if there's not going to.
The judge then explained the two paths available moving forward. A jury trial would place the decision in the hands of 12 jurors, while a bench trial would allow the judge alone to determine the outcome. No matter which option was chosen, one rule remained constant. The prosecution would have to prove the case beyond a reasonable doubt.
Prior DWIs. Okay.
No, Judge. I'll run his full NCIC if you'd like.
Please,
Yes,
you
Judge.
need to understand that DWIs are big business in Texas, you know? Watch the news. Every single day someone dies from a DWI. That's why they have made the penalty so darn severe. A third DWI, you're looking at prison up to minimum 2 years in prison, a maximum of 10 years in prison. What you're doing is you're pleading guilty to this offense. The DWI is going to go on your record. It will be there for the rest of your life. And what you need to understand is that whenever you get pulled over now in the future, first thing an officer does is they're going to look at your record. If they see that you have a prior DWI, a prior PCS, and they come up to you and they smell alcohol, they smell any kind of funky smell, what do you think they're going to do?
Take me out of the car.
No, not just take you out of the car.
Take me to jail.
Probably so. You know, from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand?
Yes, sir.
If I were you, even if you have had a sip of alcohol, I wouldn't get into a car. It's a humongous risk that you're taking. You understand? What you have worked out is 180 days in jail to be probated for 1 year. As part of the conditions for you to complete this probation successfully, you must do a DWI education class, 2 victim impact panels. You must also do what's called a TRAS. This is an evaluation to see what conditions you may need. They assess other conditions like, supportive outpatient treatment, intensive outpatient treatment. You must also fulfill those as well. No drugs, no alcohol, guardian interlock, no breath test refusal. What that means is that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it while you're on this probation. If you don't do it, you're in violation. If you violate this, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. We're going to talk if you violated your probation. If you do, you're looking at 180 days in jail. Do you understand?
And so it would also be a minimum of 30 days, and we discussed that. On this case, it's lead, so it would be a 30-day minimum.
Is he here?
So he's doing 30 days as a condition.
Sorry, we're pleading to,
Thank you to the enhancement.
pleading to the.
Say it again?
Thank you to the enhancement.
Oh, I see. Right.
No prior. He is aware that it would be 30 days minimum.
Right. So if you are revoked, it's a minimum of 30 days in jail. That's what they're trying to allude to. Do you understand?
Yes, sir.
I don't see the enhancement on here, so let me see. Is it true or untrue that you had a Class A misdemeanor theft in 2018?
It's true.
It's true, the enhancement. All right. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you are stuck with this until you complete it successfully or you get revoked. You understand?
Sir.
You still want to do this?
Yes, sir.
How do you plead to the...
Notice how the judge keeps emphasizing consequences, probation terms, classes, huge fines. It feels like he's trying to scare defendants straight. Do you think fear is the best motivator here, or would treatment work better long term?
Officer driving while intoxicated. I will find you guilty. I'm going to send it to you to the agreement. Does this also take care of the case upstairs?
Which would be dismissed in the case assertion.
They're going to dismiss the felony case upstairs. This is a great deal for you because anytime you can avoid a felony, you're winning. But you have to understand that there's only so many times, that they're going to do this where they're going to dump one in exchange for the other, especially a felony offense. It doesn't happen over and over.
Understand.
You understand?
Sir.
All right. Now, I want you to understand one more thing that, as I said earlier, DWI is big business. There is a $3,000 surcharge that we normally apply to cases like this. This is your first offense. I will waive your fee now. But if you pick up another DWI, it is a $6,000 surcharge. And if you don't pay it, every $100 you owe, you sit 1 day in jail. So you can imagine how much time you'd be doing if you pick up another DWI. You understand? We all make mistakes. But the idea is that you don't continue to endanger other lives by making these stupid mistakes. Get a clue. Good luck to you, Mr. Drew. All right. Thanks, Josh.
Judge, approaching on Jeremy Frazier's, he's on the jail docket.
Okay.
He has a felony pending that's on the docket for tomorrow for retaliation of the same incident. He has not received any bond conditions yet. The complaining witness, we verified that she's moved out of the location, his house, which is what was on the protective order. The protective order, I think they're modifying to delete the address restriction
Okay.
and whatever bond condition.
He's not made bond yet. Yeah, he's not made bond yet though, right?
No, his family's made bond. They posted the bond. They paid the bond. The bonding company hasn't posted the bond because the court date hadn't changed from today yet. He's going to make bond this afternoon.
I got it.
They're
Okay.
going to post the bond this
So,
afternoon.
guys, do you mind, he's here, right?
He is
Do you
here.
mind bringing up Mr. Frazier, please? So tell me who's the complaining witness in our assault case, if you don't mind,
The
please.
complaining witness is his girlfriend, Judge.
Okay. Are we still no contact with this person?
No contact, no weapons.
Okay. So your lawyer's asking for me to modify conditions of your bond.
What's up?
There's a protective order that has been issued in this case. So that protective order is still in place. The only thing I'm changing is I'm taking off the residential restriction so that you can go back to this house.
Thank you so much, Judge.
Everything else sticks. So
Roger that.
no weapon, no contact with this person. Do not pick up any new cases and just behave yourself.
Roger
You
that.
know what I mean? It's not hard, right?
What's up?
Okay, do you mind printing me out a copy? please? The MOAB on Mr. Frazier so we can modify. The only other thing I'm going to ask you to do is, you know, it appears from what Carl has told me that your family is going to pony up the money for you to get out.
Yes, sir.
You got to comply with the conditions of whatever bonding company that they're doing, because if you don't, they'll surrender the bond and a warrant is going to issue. You also need to remain in contact with Carl, because if Carl tells me he can't get a hold of you because you're ducking and dodging and you pick up in the case, I'm going to revoke the bond. You understand?
I know you don't play, Judge. Yes, sir.
Okay, great. So, you know, right? Okay, so I think we're good. We'll have you put back. I'll give you a copy of the amended order for protection, and then after that, you're good to go. All right. Good luck, Mr. Frazier.
Their bond conditions also, or just a protective order.
Well, yeah, we'll have to make sure that the bond conditions is so that, you
As
know.
long as they reflect it. All right, thank you, Judge.
Yeah, okay, thanks, Carl. Good morning, Mr. Black.
Morning.
So your lawyer is asking me to set you a bond. I don't know. You know, I've never met you before. I have to get to know you in a very, very short time. I need to know several things before we set you a bond. You know, you are an inherent flight risk because you're wanted out of another state for some charge I have no idea for. So we're going to get to know you to see whether we should set you a bond or not. I don't know at this point. So Amy, tell us about Mr. Black.
Your Honor, he's wanted out of Rockdale County, Georgia for possessing, displaying false ID with government logo or seal for criminal act, and also a theft by taking of a motor vehicle. State's opposed to a bond at this time. We also see that he has a bond forfeiture in Harris County, and then he also has an open warrant in Kansas for a failure to appear. Furthermore,
Did you know that?
She just told me when we were waiting on him to come out.
we have concerns about how he would even get back, considering his driver license was denied renewal in 2021 due to a failure to appear and driver.
Well, but I mean, there are other ways, right? But the more concerning fact is that he's got an open warrant in a different state as well. What is that for? And how long has that been open?
We're only seeing for failure to appear. I saw earlier it was from 2017. So he's been
It
out.
was in 2017.
Correct.
I've never even been there.
I'm just telling you what they're saying. They're saying that you have also an open warrant from Kansas from 2017. I can't possibly give you a bond when you're wanted out of two different states. One for, that's 6 years ago, man. You know, have Kansas not put a hold on him?
Not that I know of at this time. I can reach out to our central.
As the conversation continued, the defendant revealed that she was currently studying law in college. While that fact caught the court's attention, the judge focused on a more important question: whether classroom knowledge could truly prepare someone for the challenges and complexities of a criminal trial.
Not at this time. Dave was the one who told me.
So let's do this, because the cases that you're wanted out of Georgia, they're not the most egregious. You know, it's a suspended license and then a theft case. It's not the most egregious. My more concerning issue is that you're wanted out of a different state as well. So let's do this. What we can do, let's roll this to tomorrow. Can you, Amy, in the interim, if you can figure out, number one, is Kansas going to put a hold on him? Number two, what's he wanted for? If it's some kind of rinky-dink speeding, then I'm not worried about it. But if it's something serious, then I have issues, especially being that it's 6 years old. So let's do this. You know, it's a no at this point, pending what's going on in Kansas. So let's see what happens there. And then, you know, we can bring him back tomorrow and figure out. And I just need more information to be able to make an informed decision at this point. Okay? Do you have any questions?
As we reach the end, one theme keeps coming up: accountability. The courtroom isn't just about punishment, it's about forcing people to face their choices. So let me ask you, do tough judges create real change, or just harsher headlines?
Pretty much. I know somebody has been using my identity for the past couple of years because I was in Georgia, but.
And it's probably a good idea for you to do something about it and not just, you know.
I reported my identity stolen and I put out a theft report for it.
I don't know what to tell you, but I before I set you a bond in, you got to understand, I can't just take your word for it, right? Right. I have a lot of people that try to sell me the sun, moon, stars, tell me it's little bunnies jumping in the woods, to what their cases are all about, when really. So let's figure out more information. We can bring you back tomorrow and see. Okay?
Thank you.
Okay, thanks, Shabbat.
And I also have waivers for Elijah Clark and Alana Gonzalez, who had originally set her a bond, I believe it was like last week. Mother decided that they did not want to put it up.
Really?
So,
Oh, man, that sucks.
so we have her waiver.
Okay. I'll just sign it. We'll begin. Thanks. Is Gonzalez on the docket today?
Yes,
Set the bond at.
$1,500.
Hello,
I don't want to make it.
I think, no. So when they were going to the bonding companies, they kept saying that even if they did it, that she would still want it. They were giving her a hard time. So I suggested that they go put the full amount up at 49 cents a cento. She told me that they were gonna do that. And then she called me, whatever day I sent the email the day before yesterday, indicated that they weren't able to do that, or they didn't want to do that, or whatever the case may be. So she's really just been
I
sitting there.
mean, it's a lot of money, you know, and
Because I explained it very clearly the first time I called Judge. It's unfortunate that she had to sit for a week. She could have been gone to Louisiana by now, I
Right.
believe.
Yeah.
But they assured me that they would before I signed the document that day.
okay, guys, thanks. Okay, Willie. Hey, man.
Judge, this was we're bringing back from last week. I'd approached about moving his monitor. You agree to remove it, but you want to bring him in to admonish him so that there's still no contact with him.
Come on up, Mr. Santana. So he's a truck driver, if I remember correctly, right?
You got it. That's the one that you.
The unlawful restraint, is it an is it an ex-wife? Is that
No,
her?
they're going through a divorce. They've had no contact since the inception of this matter. Whether the divorce goes through remains to be seen, but as of right now, they're separating for sure.
Or you think that there's, so
I don't think.
I need you to understand, Ms. Santana, come on up. I need you to understand that, so Willie says that you guys are going through divorce. It may not happen. I hope that you're not having contact with this person, because I've ordered you not to have contact with this person.
There's been no contact.
Don't. If I find that you're having contact, and I don't care whatever mean it is, I'm gonna throw your butt in jail. Do you understand? It looks like to me like you're having contact with her. Mannerisms are a big tell, Mr. Santana. And your mannerisms tell me that you're having contact with this person. I hope and pray that you're not. Because if I find that you do, I'm gonna light you up. Do you understand? No means no, and I don't care what is going on in your life. I don't know, Willie, because I think he's having contact with her, you
Judge,
know?
there's been, I think in this case had to have been because she's still, my understanding, the state has had contact with her.
Well, I don't care if the state has contact. I don't want him to have
No, I
contact.
understand that, but I, through the calls that did not appear, her agitation level with them is pretty high that it has been. I think the board would receive no.
And Your Honor, if I may, when speaking with the complainant, she advised that she'd be comfortable with an intermediary. She does not want contact, but she'd be comfortable with an intermediary for the purpose of their children, but that's the extent that she's willing to.
Last time you talked to her.
So the last time was November and we were unable to get a hold. I can reach out now and try right now.
Yeah.
Yes, Judge.
I mean, I want to know that he's not having contact with her before I take that thing off, you know? So let me make sure, and if so, I'll take it off.
Yeah, I'm pretty comfortable with it because he's out of town.
We'll see.
He can't be.
There are many other ways that someone can reach. Take a seat in the jury box.
They were unable to get in touch with her. And Judge, so given that we're unable to get in touch with her, we're not opposed to removing the GPS. We just,
No,
we
because
just want to keep the no contact, Your Honor. That's the main thing is she wants no contact. We want to respect that. But otherwise, I mean, we don't have any indication she's not getting in contact with us about any further incidents and we can't get a hold of her now. So,
how many times have you reached out to her?
so we reached out to her.
One today.
The last time as well, last time he told me I reached out then, and then today I reached out again. I even tried reaching out to her emergency contacts on her driver's license and nobody's answering to get a hold of her.
Judge, I firmly believe that had there been an issue, she would have been in touch with the state. That would have been, he's a trucker, he's moved out, he's living in his truck. I brought him off the route.
But, I mean, all I'm doing is taking off the device,
That's
right?
it. We're
But,
maintaining the
so you're saying he's sleeping in his car, I mean, what,
Well, I mean, I brought him off route because I thought this was already agreed to that we were gonna do this last week and brought him in to admonish him to maintain no contact, which he's already been doing.
Mr. Santana, come up. Do you have an offer in this case, Willie?
Offer.
Can you put an offer in this case?
We're gonna be able to look at it, Your Honor.
I will reluctantly take it off, but I want you to understand that you're not to have contact with this person. If I find that you do, I will issue a warrant for arrest. I'm going to put you in jail. Do you understand? No means no. I don't care what's going on. I don't care who.
The discussion soon turned to legal experience. The defendant acknowledged that her studies had primarily focused on civil litigation and family law rather than criminal law. For the court, that distinction mattered. Criminal proceedings involve strict procedural rules, evidence standards, and trial tactics that can significantly impact the outcome of a case.